The president spent the morning tweeting and retweeting other people dozens of times at an almost frenzied pace, opining, in fairly typical for him fashion on how he wants to prosecute President Obama or Obama officials or something, and opining on the free press being the enemy of the people and how terrible MSNBC is and how governors who have better approval ratings from him right now, they stole those approval ratings from him. Those are his good approval. It was more than his usual level of petty and out of control, I would say, just in terms of an average census of how he behaves in public. But today it did actually take on slightly more weight than usual, because while the president literally had only two things on his schedule today. He had an intelligence brief at noon, which is the thing he is often said to skip. And then he had a meeting with Republican senators at 4. Other than that, he had nothing else on his schedule today. And we know from his public online pronouncements that what he really did all day was just tweet, including just tweeting about stuff he apparently saw and liked while he was watching cable TV. The president manifestly not busy today. But while he was showing us that, today his lawyers at the same time were at the United States Supreme Court arguing that the president should be immune from any form of investigation, not just immune from prosecution, but immune from investigation, in part because responding to requests for information in any sort of investigation is such a hassle. The president responding to any effort to get evidence from him would take up his very, very, very valuable time, which, as we saw today, he always spends in very valuable ways.
Why isn't it sufficient just to apply ordinary standards? I gather ordinarily, any person gets a subpoena can come in and say it's unduly burdensome. And what counts as unduly burdensome for a doctor who's in the middle of an operation might be very different from a person who's a salesman. And similarly for the president, all the factors you raise could come in under the title unduly burdensome. So why not just go back? Let the president say, I'll show you precisely how this is burdensome. I'm going to spend time, effort, working all these things out, figuring out what they mean, etc. And if he shows undue burden and lack of connection, he wins, and otherwise not. That's true of every person. That's Clinton v. Jones. Why not the same here?
Justice Breyer, the hypothetical you just gave, I think, proves the point. By the time you were to prepare, review, analyze the various requests, just in these three cases that we have today, shows the burdensome nature. And then to require the President of the United States, and as you raised in your opinion, in a concurring opinion in Clinton versus Jones, that burden is being met just by us being here. But to require the president to have to respond to each and every state district attorney that would like to...
No, he would hire you, and he'd hire a lawyer to list what the burdens are. That wouldn't take a lot of time. And then he wouldn't be burdened because you'd go in and say what the burdens are. And if you're right, you win that case. They are saying the other side, there are no burdens here.
Well,
you say there are. So send it back and let them figure out what they are.
I think doing that establishes the problem with an analysis of a case-by-case analysis. For instance, in this very case, in this subpoena found on page 118A and 19 of the petition appendix, there's a list of documents that are extensive. You would have to meet with the President of the United States. Could you imagine just for a moment, Justice Breyer, that and you said let's assume the President were to hire me, that I'm going to call the President of the United States today and say, I know you're handling a pandemic right now for the United States, but I need to spend a couple of 2 to 3 hours with you going over a subpoena of documents that are wanted by the New York County District Attorney. I know you're busy, but can you carve me out 2 hours?
Can you carve me out 2 hours? Yeah, that would be a very good argument with many presidents. But with this president, you getting 2 hours with him to organize evidence related to, what these subpoenas about, like, evidence related to potential money laundering, bank fraud, insurance fraud, campaign finance felonies. Yeah, you need 2 hours. This president could probably afford to give you that time. to help organize evidence about serious investigations like that. Given what we know about how he spends his time, including what he put on display about how he spends his time today, yeah, he probably could spare 2 hours with his lawyer to provide evidence.